While I was studying in high school, once during an exam time, I didn't study anything, and I sat next to a guy who I knew would surely score the highest grades. Well, what happened during the exam? You all can imagine. Cheating and copying, after all, is not an unknown phenomenon in high school students. But as one can imagine, you sow what you reap. Coincidental or just plain fate? 2 years later, in another exam in the same school, that specific guy came and sat next to me. This time, I was well prepared. The class hierarchy had changed, and he expected to see my answer sheet and copy my answers. This deed would have been easy enough for me, but somehow I hated it. I worked so hard. I worked throughout the year, day and night, many sleepless nights. And now, on the final day of judgment, he is getting exactly the same perks and same grades as me. That doesn't seem fair. This, in a nutshell, is intellectual property rights. We're going to discuss the three integral pillars of intellectual property rights in this video: the copyright, trademark, and patents. Please stay with me throughout the video so that you are aware of all these things. So the next time you go out, you know how to protect your business, your ideas, and your concept. Under the law, copyright is a legal instrument that provides the creator of a work of art or literature or any work that conveys information or ideas the right to control how the work is used. Usually, a copyright is for about 70 years all over the world, but it varies from some jurisdictions. Sometimes it's a bit more, sometimes it's a bit less. What does a copyright include? That includes number one, literary works such as books, magazines, journals, artistic works such as paintings, drawings, stuff like that, cinematic works such as movies and documentaries, or record works, which include songs and music recordings and things like that. Here is an example of what a copyright looks like. You've got novel books, you've got poetry, you've got a painting, you've got a drama serial, and you've got a pop group which makes record labels. So it pretty much covers all the aspects of what genre or what category copyrights can do. Trademark, on the other hand, is a word, phrase, symbol, a design that identifies and distinguishes the source of goods from one party to those of the others. Similarly, service marks are also a word, phrase, symbol, or design that identify and distinguish one service from another. Under the law, trademark is defined as any mark capable of being represented graphically which is capable of distinguishing or services of one undertaking from those of other undertakings. Uh, Here are a few examples over here. If you can see, I don't know if I'm allowed to take the names of these brands because of this video or not, but you get an idea that these are all trademarks and different examples of trademarks, which are symbols and designs and logos through which you can actually identify what the product is and who is making this product. So that is what a trademark is. Finally, patent. Under the law, patent is a grant of exclusive right for an invention to make, use, and sell the invention for a limited period of 20 years. The patent grant excludes others from making, using, or selling the same invention. Patent protection does not start until the actual grant of a patent. So that is very important. What can be patented? In order for an invention to be patented, it needs to have fulfilled these four criterions under the law. Number one, invention should be a process or a product. Number two, invention should be novel or new. Number three, it involves an innovative step. And number four, it is capable of industrial application. Here are a few examples of some of the registered patents in the market. We have chemical composition for medicine. We have blueprints of a building, jewelry design, and some dress designs here as well. Now that we have covered what a patent, copyright, and trademark is, I'm going to test your knowledge on a few things and see what do you think and how do you identify what is a patent, copyright, or a trademark. But before that, I'm going to show you a couple of examples of major copyright and actually trademark breach cases that have been gone down in the history lane. One is this one, and then there's another one. Now for the questionnaire part, I'm sharing a few images over here, and you have to tell me what all of these are. A hint, they're all the same. 3, 2, 1. Yes, they're all trademarks. They are all trademarks which are a logo, a phrase which show or identify a specific brand, as we have discussed previously in the video. If you don't know, you need to redo the whole video again. Now, let's do another example. Okay, so for my last example, most of you have or have seen an iPhone. So we're gonna do all three things in an iPhone. So look at or think about an iPhone and think what in that specific product is supposed to be patented, what is trademark, and what is copyright. 3, 2, 1. Okay, so the patent part is number one, disk body and the screen layout. This is patented in an iPhone. The trademarks are, of course, the logo behind the phone, or these is, I don't know if it's there or not, I don't own one. And then the word iPhone itself is copyrighted. So hence patent, copyright, and trademark. I hope through this video you have been able to understand the concept of intellectual property rights and the three integral parts in it, the copyright, trademark, and patent, and you can easily now apply them in your everyday life. I'm gonna keep on making these kind of videos for you to understand and how law evolves around each and every part of life, and I'm gonna explore those different avenues. To see more such videos, please do subscribe my channel, and hopefully I'll see you soon in another video. Thank you. Till then, bye bye.